The draft has some positive elements. It is grounded in human rights language. It's been developed through a participatory process, and it contains clear transparency requirements for platforms. Yet, some contradictory signals remain, including the risk that overbroad liability will be imposed on companies for user-generated content and that there will be limited judicial oversight. We're also concerned about other approaches to regulating companies, including requirements for legal representation mixed with threats of criminal liability, data storage and access, and taxation. India has faced serious incidents of incitement to violence online, clearly a factor in recent attempts to regulate online space. In February, India unveiled new guidelines for intermediary and digital media ethics code. This new law introduced some useful obligations for companies relating to transparency and redress, but a number of provisions raise significant concerns, including those empowering non-judicial authorities to request quick takedowns, obliging platforms to identify originators of messages, and stipulating that companies must appoint local representatives whose potential liability could threaten their ability to protect speech and even to operate. The threat of limiting protected speech and privacy has already surfaced there, including legal disputes with both Twitter and WhatsApp in the past month, which are now before the Indian courts. A number of other countries have introduced or are considering introducing extensive requirements for platforms to operate, including amendments adopted last year in Turkey, a ministerial regulation in Indonesia, or a recent proposal in the Mexican Senate, the impact of which varies significantly based on the political and legal context which they are being enforced. Of course, the ultimate tool to control online speech are internet shutdowns, including the blocking of specific apps and the partial or complete shutdown of internet access. Access Now Keep It On campaign has documented 155 shutdowns in some 30 countries during 2020 and 50 shutdowns already this year until the end of May. The High Commissioner has expressed specific concerns on shutdowns in Belarus, Myanmar, Tanzania, and Iran. In June, the Nigerian government announced the indefinite suspension of Twitter after the platform deleted the post from President Buhari's account that Twitter said violated its policy on abusive behavior. Within hours, the country's major telecommunications companies blocked millions from accessing Twitter, and later, Nigerian authorities threatened to prosecute Nigerians who bypass the ban. The ECOWAS Court of Justice has reportedly ordered recently Nigeria to refrain from such prosecution, pending the outcomes of a case filed against the Twitter ban by Nigerian civil society organization. Restrictions not always violate human rights, but any limits need to be necessary, proportionate, and non-discriminatory to be proportionate. Restrictions should be the least intrusive methods available. Yet, we see shutdowns far exceeding any need. Shutdown just doesn't interfere with speech. People rely on the internet for their jobs, their health, and their education. The impact of shutdowns on elections, when open and safe space for public debate and public protest are vital, is particularly serious. In the face of these challenges, social media companies have become something of a punching bag for everything that goes wrong online. They are harshly criticized both for failing to take down harmful content and often equally severe abuse when they actually do so. Much of this criticism is justified. The companies open themselves up for such complaints by their ill-defined and opaque policies and processes. The Facebook Oversight Board has engendered a great deal of skepticism, but it has succeeded in one important way. Its cases have shone light on previously unknown or unexplained practices that have enormous consequences for fundamental rights online. Nowhere was this more true than its review of Facebook's decision to subject former US President Trump to an indefinite suspension of his account. The board decision led Facebook to admit that it had not applied its political figures exception to President Trump's account to explain a cross-checks process we had not known existed, and to provide information on how its strikes policies work. Another huge gap relates to the opaque and insufficient avenues people have to challenge companies' content moderation decisions. For example, last May, when conflict began in Israel and Palestine, critics alleged that Palestinian voices were disproportionately affected by social media company actions. Facebook acknowledged problems arising in its automated moderation systems, and described as an error Instagram's blocking of hashtags referring to the Al-Aqsa Mosque, because Al-Aqsa is also the name of an organization sanctioned by the US government. I pass now back to Becky.
The UN Guiding Principles on Business and Human Rights stipulate that all companies have a responsibility to respect human rights. For tech companies, this means that they should take steps to ensure that they are not contributing to or linked to human rights abuses committed by those who use their products and services. The actions companies take should be proportionate to the severity of the risk. Their options include a range of measures, not just takedowns, but flagging content, limiting amplification, and attaching warning labels. Companies need to do much more to be transparent and actively share information about their actions and company policies and processes. Social media companies also need to grapple with how they address content moderation issues globally. Context is essential to understanding the potential of speech to incite violence, for example. While Facebook's experience in Myanmar led to greater investment in what it calls other, quote, at-risk countries, social media companies' capacity to understand language, politics, and society in many locations around the globe remains limited. The UN Guiding Principles on Business and Human Rights also make clear that governments have a duty to protect against human rights abuses by companies. Given the propensity for online harm, states need to put in place effective guardrails for company actions, including by requiring greater transparency and accountability. But the dangers of states overstepping the mark are painfully clear, as countless people currently detained for online posts that contain protected speech make clear. State regulation, if done precipitously, sloppily, or with ill intent, can easily consolidate undemocratic and discriminatory approaches that limit free speech, suppress dissent, and undermine a variety of other rights. We face competing visions for our privacy, our expression, our lives, spurred by by competing economies and competing businesses. Companies and states alike have all agreed to respect human rights. Let's start holding them to that. That is the end of our introductory statement, and we are now open for questions. I will be watching online for raised hands, so please let me know. Okay, I see Peter Kenny, please. I see Peter Kenny.
Taking my question, can you hear me?
Yes, I can, thank you.
Yeah, I just wanted to ask you, you were talking about this is relating to businesses and states, but how does this apply to bigger organizations like the UN, for instance, in terms of access to information? Because I think journalists sometimes have complaints that the system that operates does not give them full and free access always to information that they need in press conferences and such like instances when they cannot easily question and access the information that's needed. Thank you.
Thanks, Peter. We are looking very closely, and my colleague Scott Campbell may want to add on this, at the way that the UN implements human rights standards with regards to new technologies. The Secretary General, in his roadmap on digital cooperation, specifically looked at how the UN itself does human rights due diligence on how it deploys new technologies. With regards to access to information and content online, obviously the UN isn't itself a social media provider, nor a state, and doesn't fall within the specific regulatory or UN guiding principles on business human rights. But the idea that the UN needs to be careful in the way that it uses these spaces, that it needs to provide access, free access to relevant information, and avoid mis and disinformation is obviously part and parcel of what the UN is committed to doing. Scott, anything you want to add on that front?
Thanks, Peggy. Maybe just quickly that indeed, I mean, the Secretary General has stressed he has a new strategy out last year on how to use data, how to leverage information so that we can be more effective at meeting the SDGs and promoting and protecting human rights around the world. A challenge there, and a challenge in access to information, is of course relates to issues of confidentiality and information that may be sensitive. And this is something, of course, that's a very frequent concern in our work in the UN Human Rights Office. So access to information, access to data, the Secretary General, obviously underscored, is key in terms of making us more effective as the UN. But at the same time, there are those concerns about data protection and data privacy. And the Secretary General, in parallel with his efforts to make sure that we're applying the human rights due diligence in how we're using information, how we're using data, has also undertaken an effort to develop a policy that's specifically around data protection and data privacy, which is something, my colleague Tim Engelhardt has been working on as well. Over.
Thanks, Scott. I see Stephanie Nabehe has her hand raised as well. Stephanie, I have met, but if people can make sure to introduce themselves when they ask their questions, please. Stephanie, over to you.
Thanks very much, Peggy. Stephanie Nabehe, Reuters. Two questions, if I may, because I think they're of general interest. One would be regarding former President Trump's lawsuits filed recently against Facebook and Google as a parent company, and Twitter, alleging that they've tried to silence conservative viewpoints unlawfully. So I realize this is under adjudication, but would you say that that he has a case against such media companies that have just that have put on this in the case of Twitter, at least, sort of an indefinite ban, and then perhaps if you could indefinite suspension in the case of Twitter. And then if I could come back with a second question after you're able to address that, please. Thank you. Or would you rather have that first?
I'm fine with just taking that one, so we make sure. Thanks for the question. It's obviously really interesting issues. I'm not in this instance, going to opine specifically on U.S. law, but the 2 points that I'd make in response to those lawsuits. The first is that what we have seen in monitoring the space and what I think has been fairly well documented is that while there are many ways in which the company's policies towards content moderation are subject to criticism or improvement, the idea that there is some sort of overall silencing of conservative voices that's disproportionate compared to other voices, I think, doesn't have a solid evidentiary base. Now, what impact that will have ultimately on a legal suit, that's for the lawyers to say. I would also mention, as you said, that as it relates to sort of the silencing of speech generally, the idea of either indefinite or permanent bans. Actually, it's interesting that Facebook did an indefinite suspension, and that got them into trouble. Twitter, on the other hand, it's supposedly a permanent suspension, or ban. What has happened, of course, in that case is that the Facebook Oversight Board has said explicitly, first, that Facebook didn't follow its own rules because they didn't have a provision for indefinite suspension. And then has said, looking at and very explicitly, Facebook looked at the relevant human rights standards, referring to, for example, the International Covenant on Civil and Political Rights and the commentary there, to the Rabat Declaration. So a very detailed analysis of human rights law, which we are pleased to see. And what they found is that there needed to be greater that the original decision to suspend was supportable, but that, again, the response has to be proportionate, as we've said in our introductory remarks. And so one of the questions there will be, and I think will continue to arise, is whether a permanent or indefinite suspension can ever be determined to be fully proportionate. And I think that's a question that we'll see coming up again. Back to you. So Stephanie, for your second question.
Yeah, I'm back. Can you hear me? Yeah. Whoops. Yeah. Second question, please, regarding you alluded to the racist, epithets and behavior following the Euro, the final in Wembley in the UK last Sunday, and your concerns about